today. We are going to be talking today about easements and restrictive covenants and their effect on the land that has the benefit and the burden of those rights. There will be an opportunity at the end to ask questions, so please don't speak up or put anything in the chat, but scribble down anything you want to ask and do feel free to raise it at the end. Welcome to our presentation. We are going to be talking today about easements and restrictive covenants, including how they arise, how they operate in practice, how they might be challenged, and ultimately whether it's possible to remove them. So, with easements, we'll be looking at, and restrictive covenants, we'll be looking at the creation, so the formalities of doing that, which parties are necessary, and how it applies on a broader scope with perhaps a building scheme for easements and restricted covenants, both express rights, prescriptive rights, and how they might arise when you are not expecting them. We will be looking at the benefit and burden of restricted covenants and if they run with the land. We will be looking at how they can be interpreted, how the rights have been applied by the court, how people have dealt perhaps with challenging them, and ultimately what the remedies are if somebody is breaching your rights. So just to state at the outset, where you are in a local or working in a local authority, there may be statutory powers that would override easements or restrictive covenants. But before you make the decision to do that, obviously it's helpful to understand what the issues and the other options are so that you can make sure you're making the right decision. So, if advice is needed on a topic such as this, it will probably cover both options. So, it may be that some of the things that here today that would be more of a problem for a private party, such as a limited company developer, wouldn't necessarily give you the same issues. But as I said, you can't make a decision until you've looked at it in the round. So, starting with easements, what does that word mean? It is a rather archaic sounding word. What it basically means is third party rights. So, it's the rights that and somebody else might have over your land. It might be a neighbouring owner who has got used to using your driveway, or it might be people dog walking over land that's in private ownership, or something along those lines. Once an easement has been created or once it's arisen over time, it will continue to be binding on the land where it can be carried out, and it will continue to benefit the owner of the right, even if the properties are sold. Easements are usually positive in nature. That means that they allow somebody to do something, but they can also be negative in nature. So, the classic example there would be rights to light, which can actually prevent you from building or developing an adjoining site if it would interfere with lights through a window in the neighbouring property. So to consider how can easement, why should you care? How can an easement affect the property? Well, it can be fairly minor or it can be really quite substantial. Third party rights to use part of your land could actually get in the way of future use or development. So for example, if the land has been sitting unused for a while and then it's brought into a plan. Oh, I apologize. I've had a note from somebody say they can't. Can anybody hear me? Because one person says they can't hear.
I can hear you, Jill.
Yeah. Okay. Apologies. Apologies to the person who can't, but thank you to those who've confirmed that you can. To the person who can't, maybe try dialing out and back in. Fingers crossed that will help you. Um, so yes, so third party rights to use your land, they can give you a problem. If, for example, as I said, you've had an area of land that's been sitting unused for a while, and now the local plan has got it allocated for housing or something, and the council wants to sell it for housing, to find that people have been, for example, walking their dogs over it or parking their cars on it, and you were unaware of it, that could be a real problem. It might be necessary to amend or abandon a scheme, or for a local authority, possibly if you have statutory rights that could override it, it could be quite an extra expense. If you're acquiring land, it's also essential to do proper due diligence before you buy it. Again, if, for example, the council were looking at acquiring land for a specific use, you wouldn't want to find afterwards that you get a letter before claim from somebody, let's say a shop owner, alleging that their customers have been parking on that land for 30 years. So doing proper due diligence on acquisitions is also important. Um, Again, if you're selling the land, if you say that there are no third party rights and then somebody claims one, you can find yourself on the wrong end of a misrepresentation claim, which is never fun. It's therefore important for all landowners to be diligent, to take care over who is using their land and why. And of course, local authorities can be particularly vulnerable there because they tend to have much larger property portfolios. People in the real estate team might not even necessarily know everything that they own. And if it's land that's not being utilised immediately, there is a risk that people will start using it as a shortcut or for parking or something like that. And so it is prudent to ensure that the properties are being managed carefully. And if there is any issue, if you start to notice things like cars being parked there or what you might call a desire line where people have clearly been walking over it and have left footprints, if it's open land, then making your inquiries and taking legal advice will be important. An easement has to fit into the legal box. So not everything can be an easement. The leading case on easements has been around for a while. It's called Re Ellenborough Park. And back in the 1950s, this was a development that had pleasure gardens. And the question arose as to whether using the gardens just for pleasure was capable of constituting an easement. And in the course of deciding that, the court set out the four key boxes that need to be ticked, which are there must be a dominant property and a servient property. So you must have one that's using the other effectively. The easement must benefit or accommodate the dominant property. So it can't be something that's completely irrelevant to the use of the dominant property. The owners of both properties must be different parties, so you can't have an easement against yourself effectively. And finally, the easement must be something that is capable of forming the subject matter of a grant, i.e., it must be capable, or if you are going to grant an easement, it must be something that somebody can actually do to use the land. So some examples of common easements that we see in practice, positive easements, the most, probably the one everybody thinks of first would be a right of way. You can also have a right to park. You can have a right to run conduits under neighbouring land for electricity or water or drainage, etc., or to discharge water coming off the site into a watercourse. You can see from those how if you wanted to develop or if somebody was developing next to you, etc., and the land had been being used for those purposes, that it could be a fairly substantial issue. Negative covenants that we often see, although they might be worded positively in that they might say something like to allow the flow of air, what it actually means is you can't build anything that would restrict that right. So that's why we call it a negative easement. But again, rights to light is the biggest one. And don't worry, I won't. But I could talk for several hours about that one on its own. But there are also right to receive air, the right to support from neighbouring land, which again can be important either in the context of development or if something happens, say bad weather that damages a property and then the adjacent property is damaged. So that can be a big deal as well in the context of property litigation, or something like the right to receive a flow of water for a man-made watercourse. Things that can't be easements, just some examples here. This is obviously by no means a definitive list. If you have a license to do something, for example, to erect scaffolding, that won't be an easement. A right that doesn't have a utility or benefit other than pure recreation, then it won't be an easement. Now, I'll come on to talk about that case there on the next slide, but essentially that was the court developing the principle in the Ellenborough Park case, which is what is a utilitarian use and what is pure pleasure. There's no easement over natural rights that come from the land itself. So, for example, if there's a natural stream on the property, again, the rather archaic sounding profit à prendre, which is the right to take something rather than to use the land. So, examples there might be crops or wildlife rather than actually using the land itself to do something on the land. There might be rights where there's no dominant tenement. So, there might be a right but it's not an easement. That would be, for example, people walking who, if the village has always walked to church the same way, but the people walking have changed, then that wouldn't be an easement, but there may still be a right over the land. And finally, public or statutory rights where there is no dominant land. Now, for local authorities, that tends to be things like highways or for utilities, with statutory undertakers, they will have the right in certain circumstances to run conduits across private land, and that wouldn't be an easement, it would be a statutory power. They're looking at the four requirements in a little bit more detail. As I said, there needs to be a dominant property and there needs to be a servient property. The easement must attach itself to the dominant land. So that means it's usually in the vicinity of the servient property. It doesn't absolutely have to be right next door to it, but it's usually pretty nearby. So, for example, if you're going to have a right of way, it's more likely to be over your neighbour's land than over land that's absolutely miles away because you wouldn't be going anywhere. So that they are usually, if you're trying to do due diligence, it's usually in the vicinity. But it doesn't have to be, serving property doesn't actually have to be physical land like a field. It can be something incorporeal. So again, with the profit à prendre, in the Hanbury and Jenkins case, what the court held was where there was an existing intangible right, i.e., the right to go fishing, where people had then been parking whilst they were going fishing, they were able to acquire a parking easement that attached to the right to fish rather than to, say, the actual land. It is important, though, that the servient land is defined sufficiently. You can imagine the disputes that arise if you're going to claim you've got a right of way, but you're not quite sure over which land it goes. And so, where you might be granting an express easement, say you're selling off part of a site, the best way to avoid any disputes is to use a very clear plan. The next one, the easement must benefit or accommodate the dominant property. So it must be reasonably necessary for the better enjoyment of the dominant land. Well, that's that word reasonable. We use that all the time in the law. What does it mean? Well, it means it must be connected with the normal use of the dominant land. For that reason, as the properties don't need to be immediately adjacent, but they do need to be reasonably close together. And the easements must give a real and practical benefit, and they must be necessarily connected to it. The next requirement, it must benefit or accommodate the dominant property. So it's not necessary that if you're trying to claim that you've got an easement, if it's impossible to use your land without it, that would help, but it's not necessary for that to be the case. However, if there's no real connection between the easement and the dominant land, then it will simply be a personal right. So in the case there of Beach and Kennelly, it was where part of a garden had been sold off. There was a right of way over a footpath, and where the tenant of the property was using it just for about a year or so, and all it allowed was to walk to the end of the pathway and back, and it didn't go anywhere. It was determined by the court that that couldn't be an easement because it didn't give any benefit, and so therefore there was no point. An easement must benefit the owner of the dominant tenement as the landowner of that property. So it's not just a personal right, it's got to actually be something that goes to the heart of his owning the property. But if the easement is being used because there's a business on the dominant land, that will satisfy it, provided that the business is that of the person who owns the dominant land. The next one, the owners of the dominant and servient land must be different parties. So it's very important to check the history of the matter so that you can see whether the land has ever been in common ownership. And again, we do see that perhaps more frequently with local authorities than anyone else because they do have a habit of so that there might have been a reason in the 1960s to sell off some land, and then by the 1990s it was desirable to have it back for other reasons going on in the area. So if originally land was sold off and an easement was granted, but then the land went back into common ownership and then it was subsequently sold on again, that period when it was in common ownership may have been enough to remove the easement. So again, that your legal team or your external lawyers will need to go back and look at the history of the titles to see whether they've ever been in common ownership since the easement was created. You cannot have an easement over your own land where you're in possession of it, but you could grant an easement over land if you are not in possession. So, for example, a landlord could grant an easement over adjacent land for the benefit of his tenants. The classic example you might see there would be if there's a car park, for example, that's adjacent to the property and the spaces aren't being demised as part of the lease. But care would need to be taken when you're doing that, just to make sure that if there's then a sale of part, an unwanted easement doesn't arise. The next one, taking each of the four requirements in turn. First of all, the easement must be capable of forming the subject matter of a grant. So that means it can't be woolly, it can't be vague. So you can't just say, I've got an easement over that view, because you can't define the view. It must not be so extensive that the use of the easement would exclude the owner of the servient land from his own property, or so go so far that he would reasonably not be able to use it himself. And the case there of Batchelor and Marlowe, in that case, the court established what they call the degree test. So it's a question of fact and degree as to how much it's being used. So in that case, parking up to six cars Monday to Friday, 8:30 to 6 p.m., the court felt that went so far as to prevent the paper title owner from really using it. So therefore, his ownership would only be illusory, so it couldn't be an easement over his land. That, though, would be, you wouldn't want, I think, to be left with that as your only argument. For many years, as I mentioned before, with the Ellenborough Park case back in the 1950s with the garden, it was determined that the right must be practical and not merely recreational. But this led to rather uncertain standards, and indeed in Ellenborough Park, which did concern communal gardens for the estate, the court did comment something along the lines of what could be more pure pleasure than a garden. But in that case, they did find that it was an actual tangible benefit to the residences, not just for pleasure. You can imagine, though, how that wording has led to a huge number of queries and disputes over the years because one person's use is another person's recreation. And so the court has more recently, in the Regency Villas case, reflected that modern life has changed. And so that was a case about using sporting facilities and gardens, and whether that was capable of being an easement or whether something like a television room was simply recreational. And in that case, the court said that modern life recognizes the advantages of those facilities and that a gym or a television room is, no necessarily recreational or no more recreational than a garden or a golf course. And so the question now is not so much, is it just for fun, as is it a specific right that can benefit that specific property? And so in that case, those people did get their easement. An easement will be binding if the formalities are complied with. And so if an easement is granted expressly, which is obviously the preferable way to do it, because although that doesn't guarantee no disputes, it means that it's easier to establish the parameters. If it's an easement that's been granted more recently, it will be a registrable disposition, and so it has to be registered on the title of the servient land at the land registry to be legally binding. If that does not happen, it will not be legally binding. It will only take effect in equity, which can make it harder to enforce. And in particular, if the servient land is then sold, unless the bona fide purchaser for value is specifically on notice of it, then it won't bind a future purchaser. So if you think you've agreed a vital easement for your property, but you do not register it, and then your neighbour sells their land, then you will lose it. So it's important that the benefits are registered as they should be. Obviously, it's generally good practice to do that as well, so that the land registry is an accurate record as best you can get it of what's happening on the ground. Easements acquired by prescription, though, rather than by express grants, which I'm going to talk about next, those are legal easements. They won't be registered, or they may not be registered, and they will still take effect in law. So they are the more difficult of the types of easements that we see. Looking in more detail at how we create an easement, legally speaking, the only way to create an easement is by grant from the owner of the land where the right is being exercised to the person whose land is benefiting from it. And the three ways of doing this are express grant, implied grant, or a presumed grant. I will go into some of the technical detail now. Essentially, the easiest way to think of it is that an express grant will have a deed, whereas the others will turn on the physical features of the property or what's been happening in practice for the last 20 plus years. And you can probably guess from those which is the most contentious point that we see in practice in the litigation team the most frequently. With an express grant, this will be done deliberately. So a right of way granted for access when part of a property is sold is perhaps the most common example that we see. There is no set legal criteria, and the parties can word it however they can agree it. But if it is not granted by way of deed, it will not take effect in law. Again, it will only be equitable, and that leaves you with the problem that I mentioned earlier if it's not been created as it should have been. Where you're doing it on purpose, expressly, careful legal drafting, very clear plans is the best possible way to avoid disputes further down the line. Now, you can never guarantee, of course, that somebody with plans for their property won't try and challenge it anyway, especially if there's a lot of money at stake, but you will help yourself tremendously if easements are granted correctly. Similarly, if you are acquiring a property, and you're being told that there's an easement, you may want to insist that the seller regularizes the position as part of the deal. The next one would be an implied grant. So Section 62 of the LPA implies easements. What that statute does, it automatically adds into any conveyancing, even if it's not in paper on the page, it automatically adds in that the sale will take effect with the benefit of existing easements and rights. Now, in practice, most modern conveyancing contracts will exclude that, or leases, etc. They will exclude that because otherwise it's extremely broad, and you don't, as the seller, you don't actually know necessarily what you'd be deemed to have conveyed. So it's often struck out, but if it's not, that's what it will do. You might also find an easement of necessity. So again, if the council sells off a parcel of land and it doesn't grant an express easement, and then there is physically no way to get to what it's sold, then it might be found that there is an implied easement because otherwise you couldn't use that land. And also, there may be an implication where it was clearly the party's intention that the land be used in a particular way and that the easement is necessary to allow that to take place. Now, again, I do not think you would want to be left having to argue that that was the intention. It's obviously far better to have it documented properly at the outset, but this may assist if it's found that something has slipped through the net, perhaps a property that's been in ownership for some time, and now there's an issue with regularizing it. So these are fallbacks that you don't want to have to use, but they do arise. There's also case law or common law, which is the famous case of Wealden and Burrows. Now, what that will do, it applies on a sale of part where the court will imply a grant of all the continuous and apparent easements over the retained land that now becomes the servient land that are necessary for the reasonable use of the land that's been sold. And to illustrate that, in Wealden and Burrows, Mr. Tetley, who owned some land with a workshop on it, first of all, he sold the workshop to Mr. Burrows, and then he sold the adjacent land to Mr. Wealden. Mr. Wealden then built a wall on his part that then obstructed the light to the windows of the workshop. And so the question for the court was to decide whether Mr. Burrows must have had an implied right to light over the land bought by Mr. Wealden on the basis that Mr. Tetley would have had that when he owned both pieces together. Now, again, you can see from that, although it could be very useful in some circumstances, it's very broad. And so, again, it is not at all unusual to see contracts that exclude this from applying, basically to try and protect the seller from something that could come back later on that was unexpected. But if that's not excluded, then that could also be an issue on sale of parts. Implied easements, safe to say, can be fertile ground for litigation, and for that reason, you often see them excluded. Perhaps the most complicated, and you can see to a degree some mental gymnastics going on here on the part of the law, is when an easement arises either by presumed grant or by prescription. And there are three ways that this can happen: a common law, a statute, or by lost modern grant, which is effectively, as you'll see, a polite fiction. So with presumed grant or prescription, we're not looking to create a new easement here. This is something that is used where you are trying, or the other side are trying to confirm the existence of an easement. So the key date that you really want to take away with you from this today is 20 years is the danger point for an easement. If somebody can say they have been doing something on your land in the way required by the law for 20 years or more, you may be at real risk that they will have acquired an easement. And in order to sort of ratify this, the law relies on a presumption that there must once have been a valid easement that has been lost or destroyed. And that presumption in turn relies on the fact that it must be a right because it has been being enjoyed over all those years. It must be capable of being an easement. So, for example, a right of way. So the fact that you have been using it for so long, or your opponent has been using it for so long, is deemed in and of itself to be proof that a right of way is capable of being an easement. So you won't be able to claim a presumed or a prescriptive right if you don't tick the following boxes. It's essential that you've used the servient land as of right, i.e., as if you were entitled to do it. So if you've used force, if you have used a Land Rover to drive over a gate, that won't do it. If you have been doing it, if you've been using a right of way under the cloak of darkness or with a Harry Potter invisibility cloak or something in the middle of the night, then it will be too secretive, and again, it won't work. And the third way that a claim would be defeated is if the landowner of the servient land has given permission. And that is perhaps the point that comes up again the most often in practice. But if you do not meet these 3 points, or rather if you can't tick all those boxes, then you're not going to be able to prove that you've acquired the easement. So what people often do to try and avoid this, you may see signage on the land. It may say something like, with the permission of the owner, but without liability. And once now I've said that, if you haven't seen one of those signs before, you probably will. You tend to find them in things like pub car parks, where it could be a good shortcut through the high street. And that sign is put up in a bid to stop anybody from subsequently claiming that they can that they can walk across and do whatever they see fit with the property. So to look at some examples, betterment properties there, in that case, notices to the world at large were found to be sufficient to have prevented an easement from arising, even though they'd been put up by the previous owner. And so in that case, um, the the person who wanted to build them was trying to argue that he was trying to argue that the notices were sufficient. And in the end, it was held that even though they weren't addressed specifically to the people using the rights, it was still enough. In Winterburn and Bennett, in this case, there were signs in a car park that said it was only for use by members of the club. And the problem they had there was that it was too contentious. So where the sign said any other use would be too contentious, that means that you're using it. You're using it. So you are using it without my permission, and therefore it's because it's a contentious use. It's not with permission. So the notices there weren't as useful. But in Nicholson and Hale, a sign that said private property by a staircase was held to be sufficient. So in these cases, and again, they will all be, there's no use getting too hung up on the specifics because each case will turn very much on its own facts. So they're only a light guideline really as to what the court might do. But what is clear from those cases is that the servient landowners weren't obliged to go quite so far as, for example, erecting physical obstructions or taking legal action to stop the use. So the duty didn't go so far as if you hadn't sued somebody for trespass, it wasn't quite that bad. But nonetheless, if you do discover there's a risk there's either a risk or somebody actually is using your property, you would want to take appropriate steps to stop them doing so before the 20 years has passed. The burden of proof is on the party who is claiming to have acquired the benefits of the easement. But if they can show that, if they can show that they've satisfied those criteria of as of right, without force, without secrecy, without permission, the law will then presume that they have indeed been doing it as if they had every right to. So it is a rebuttable presumption. The owner of the land, the servient land, has the ability to challenge it. But so in order to be able to do that, in order to be at risk of the easement being acquired, the servient owner must know, or at least be taken to know, of the use, and it must be reasonable. They must be in a position to prevent it if they wish to do so. So, for example, if you know that somebody is using your field as a shortcut, you could put a gate up that would prevent it. That's the sort of thing that you could do. If you could have done that and you don't tell them to stop, put up a gate, do something, then you'd be more at risk. So, and for the people who are looking to claim the easement, or for somebody wishing to try and put forward a defence, acquiescence is very useful. If you can show that the servient owner has acquiesced in the use, then that will defeat a subsequent argument by the servient owner that he had no idea what was going on. That's so permission is perhaps a stronger and an easier to run argument, but even if you can't go so far as if you can't go that far and you haven't given permission, you need to be careful that it's not used against you and they say, well, you've actually acquiesced in it. So an example might be where you've known they're doing it, you haven't actually said they can do it, but you haven't done anything to stop it. It's important there that the servient owner has had knowledge of the use, or at least the ability to find out about it. Now, as you can imagine, that's a fairly broad, but depending on the use, at least, that can be fairly broad. So, for example, if it's parking, and a simple walk or drive by the land would have revealed lots of cars parked there, then obviously you're going to be deemed to have had the ability to find out about it. And it's going to be no defense to say I didn't know it was happening if you've had even the slight hint that it's happening and you've done nothing about it. So the test will be if, as an ordinary landowner, taking ordinary, sensible, diligent steps to protect your own property, you would have become aware of the use. You can't then say, well, they concealed it. So it all comes back to this point about generally being diligent about monitoring land and what's happening on it. The easement must be continuous. So the person claiming the easement and any predecessors who've been doing the same thing, they must have been using this right as of right whenever they wished. Neither statute nor case law gives a set period that could be used to argue that it's just isolated. So there's no handy case law that says if they only use it 5 times a year, it doesn't count, but 6 times a year would. It's not that straightforward. It will again turn on its facts. So whether they've just had a cheeky shortcut once or twice, or whether they've acquired a right of way will depend on the use itself and the land itself. The use need not be constant, as in 24/7, or once a week, or absolutely ongoing all the time. But if it's not constant and there is a bit of an interruption, say you use it every week for a few months and then you stop for a few months, then you go back to it, provided that you stopped for your own reasons and not because the title owner has interrupted you, then that will be sufficient. So again, if you're looking at it with the landowner lens or lenses on, you can see that interrupting it is possibly one sensible way to try and stop time running. I will caveat that by saying you also need to be careful, though, that you don't inadvertently then allow time to start running for adverse possession, which is outside the scope of this talk, but it just underlines the need to get legal advice before you say anything. Um, so yeah, so but it is important that the interruption is done in the right way by the owner of the servient land if they want to try and stop continuous use from running. It's often useful to illustrate that with case law. So probably the longest case name I think I've ever seen there, which was a dispute about a track that allowed cars and other vehicles to access a churchyard in Gloucestershire, where the vicar of St James's Church, which was part of a group of people who were using it, was trying to argue that the church had acquired a prescriptive easement over that track, and the question was whether the church had already been able to acquire an easement, even though they'd stopped using it some 4 or 5 years before the case law. And in that case, the church won. So even though there had been an interruption, it was still found that they'd already satisfied the criteria. So there is no set standard of frequency, but it's important to note that the use must be so regular that it would put the owner of the servient land on notice that there might be a right arising, so that action should be taken. Now, again, you can see in that churchyard case, if every week for however long you have a number of vehicles appearing and driving over the track, things like tire tracks, even if you aren't there to see the cars coming and going, it should be obvious that a number of cars have been driving over the land. Some of you may remember reading about another case here, which is just a good illustration, Coventry and Lawrence. This was a very famous case a few years ago about motor racing. And this is just an interesting one, which I wanted to flag for you because we talk a lot about things like rights of way and right to light, but this one was slightly more unusual. And in that case, they were able to acquire an easement, i.e., the noise that was made from racing, because they were able to acquire an easement to make that noise over the surrounding land. What would otherwise have been a nuisance became permitted by an easement. It's a significant case for many reasons, but the fact that you can have easements to do other things, it's just worth underlining that point. So, looking at other ways to acquire an easement, the Prescription Act of 1832. This was passed obviously quite a long time ago now. It's quite an old lady of a statute, but it was passed to avoid the need to prove that use of the land started before 1189. The reason we have that rather unusual date there, that is taken to be the date that legal memory began. And so people who were trying to prove easements were having to prove before this act, they were having to prove that the use had started before then, which obviously was quite difficult to do, even though it was 200 years easier then than it is now. Um, so if you can meet the criteria under the statute, so again, as with common law, the user must be as of right, excluding rights to light. You must be able to show at least 20 years usage immediately preceding your claim. But if you can prove more than 40 years, it will be indefensible unless it can be defeated by an express written consent. So it's easier than the common law because of the date. But other than that, it is a fairly narrow way to acquire an easement. But it can be useful in certain circumstances, especially where your claim is fresh and is immediate. It's often it's often comes up with things in conjunction with some of the other rights, particularly with right to light, where it's sort of carved out there under the Prescription Act that it will be an absolute right unless it's been enjoyed for 20 years without interruption, unless there is a consent or express agreement. And that, of course, can be a real problem for development, where the world is now changing and obviously more and more land is being built on. So for that reason, when we do modern conveyances now, you'll often see there's a reservation there for the person who's retaining the land to build in the future, even if it interferes with rights to light. That will be construed as express written permission to enjoy the rights to light, which would defeat the claim for an easement for a right to light under the Prescription Act. The next one, and this is where I talked about a gold medal in gymnastics, the doctrine of lost modern grants. So this sort of arose. It's a court written fiction put in place, and again, it's really intended to resolve the problem where the claimant can clearly show that he or she's been doing something for a very long period of time, but they can't prove 1189. And so the court sort of makes this assumption that there must have been an easement at some point, but everybody's lost the deeds. So that it does sound a little bit farcical when you spell it out that way, but that is effectively the view that the court will take, that at some point, oh, you would have granted them that right, but now nobody can find it. That will apply only where the dominant owner can prove that they've been doing it for 20 years or more. But the distinction between this and the statutory claim is that the period of use need not immediately precede the claim being brought. So you can see there the advantage that might have if they can't prove use since 1189 and they've been stopped in the interim from continuing the use, which would be required under the statute. So between the statute and the doctrine of lost modern grant, most scenarios are usually covered. There will be no presumption, though, if there can be another explanation for the dominant landowner using it, and the presumption will not be rebutted if you can show there was a mistaken belief that a right had been expressly granted, or if there is circumstantial evidence that proves that a grant couldn't have been made. I won't go into it now, but it can get much more complicated if there is a lease on either dominant or servient land. Again, specific legal advice would be needed in those circumstances. So what sort of questions come to us in disputes? Well, we quite often get asked to interpret the scope of an easement, and particularly as owners and users of land change, the nature and extent of any easements can require a rethink. So where you've got a nice, neat deed with an express easement, the starting point will always be the wording of the deed itself. Good example recent there from the last year or so, the Hambling case, where the deed said only for access to the field meant that the roadway they couldn't carry on down it to the cottage. Had the court took the view that had that been the intention, the deed would have said for access to the field and the cottage. But for prescriptive or implied easements, the starting point will be the facts and circumstances and the context of how the easement arose. And of course, in the famous words, recollections may vary. And that can therefore make these types of easements more nebulous and more likely to be the grounds for a dispute. So, a common example to illustrate with an example, if you've got a right of way over somebody's land, do you also have the right to stop and park? Well, even if it doesn't say so in the deed, the court might be willing to imply a right to stop and park if there is nothing else in the deed to rule it out. So if the deed said without stopping at any time, that would override any implication. And secondly, if it's reasonably necessary for the use of the dominant land. And there's some recent case there, and a much older one that we still use today, the Bulstrode and Lambert case. The issue can also come up, for example, if you're looking at how wide the right is. So does the right to use a roadway also include the verges? So in the Carpenter case there, the question was whether they only had the right to use the tarmac or whether they could also use the grass verges alongside it. And the court there held in favour of the servient landowner because the right was specifically marked. It was clearly shown on a plan as being over the tarmac track. When you're trying to establish the scope of an easement, the physical characteristics will be important. So the court will consider things like what was on the ground at the time, width of gateways, that the width of the track, that sort of thing. Easements, we're looking at again, a key question will be what would happen if you change how you're using your land or if you greatly increase the use of the easement. It can be a big issue here, for example, where one house might be being demolished and several new houses being built. Given that modern requirements often mean development, it's a question that we see all the time. Interestingly, just increasing the easement on its own is not a reason for the servient landowner to object because the scope of the easement might be much broader than what the beneficiary, what the beneficiary is currently doing. So if you have a grant at all times and for all purposes, for example, if the person who previously had one house wants to put up a hotel, well, that right may well be broad enough to let them do it. Conversely, factors such as these may operate to stop change or intensification. So express wording in the grant, the context in which the grant was made at the time it was made, physical dimensions of the easement. So for instance, it's no use arguing that an easement for all times and all purposes allows you to drive construction traffic down there if it's a footpath. For prescriptive or implied easements, it will also be important to look at the actual use upon which the easement has been claimed. Where the use of the dominant land is changing, so again, for example, multiple houses are going to be built on something, one of the key questions will be, does the development of the dominant land constitute a radical change, or are they simply changing the use of the right? And secondly, would that new use result in a substantial increase or alteration to the burden on the servient land? And in the case there, the McAdams Homes case there, a property was changing from a bakery to two residential houses, and whether that would extend the use of the drainage so much that the easement to drain would no longer apply. And in that case, the court did say that it would be too much strain and therefore the easement was suspended. So you need to look at what's actually happening, whether the use is changing and whether the use of the actual easement itself is changing. To try and get rid of easements for extinguishment or abandonment, once it's in place, it can be very difficult to shift. So obviously that I caveat that by saying local authorities may have statutory rights. Other than that, though, the main ways in which you can terminate an easement, you could look at buying the dominant land so they come into common ownership, which would extinguish it, then you could sell it on. You could enter into an express agreement for a lease with the owner of the dominant land, but of course they may see that as a blank check. There may be statutory rights or completion of works in compliance with the statutory order that may extinguish the easement if it was then no longer possible to prevent it from being used. If the easement relates to a structure and you lawfully remove it, that will terminate the easement. And also, you may be able to argue, that it's been abandoned by the beneficiary, but that is very difficult to prove. So, sorry, I'm going the wrong way. There we go. You can see from that the first two bullet points are going to require negotiation and agreement. If you don't have any statutory rights or it's too expensive to use the statutory rights, you might want to try and consider whether you can argue abandonment. It's very, very difficult. The courts lean against taking rights away from people, but you might be able to do it in circumstances where the original use is physically impossible or the dominant land has physically been separated from the right. So, for example, a structure with rights to light has been demolished. But it's important to note that just not using it may well not be enough. And in that case, on the board there or on the slide there, even 175 years of not using it was not enough. So what's relevant, what the court will look at is the intention of the dominant owner and whether he meant to give up his rights. It's also important to notice, just as you can interfere with your own defence by acquiescence, if the owner of the dominant land acquiesces in interference with his right, he may then be stopped or prevented from objecting to that. So, for example, where he has allowed something to be dumped on a right of way, that may that may then prevent him from challenging that interference in court subsequently. So, what do you do if somebody interferes with your easement? Well, it could give rise to a dispute. The claim would be an action in nuisance because it would be interfering with a property right. But it's important to note that not every interference will give rise to a valid claim. It has to be a substantial interference. So the test is not really whether what is left after the interference is reasonable. The test is more, can the beneficiary reasonably insist on having the whole of the right? So if they have a right of way over 10 feet of roadway and it gets moved to 9, is it reasonable for them to insist on it going back to 10? And the court will look at whether they can use their right as conveniently as they could before. It will be very, very fact specific. Each case will turn on its own facts. It's also important, as with the case we looked at with the parking before, an easement is not exclusive use. And so not every obstruction put up by the servient landowner will be considered interference. Quick example on interference with easements. If you put up a gate over a right of way as an illustration, provided you tell them, you give them a key or a code, that may not be an interference, provided it doesn't mean they have to stop somewhere dangerous to open the gate. But if you open a third, if you make it too difficult, so in the Kingsgate case there were two gates that were already not that far apart, and then they put a third gate in the middle, that was deemed to be going too far. The owner of the servient land, you can't just reroute the right unless you have an express right to do so, such as a lift and shift. But if you do put something on the land that gets in the way, then the owner of the dominant land may be able just to walk round it so long as they stay on your land only. And again, we've just flagged there as a local authority, you may have statutory powers that you can use as an alternative. The remedies for interference with an easement are an application to court for an injunction or a declaration alongside damages. In certain circumstances, you may go onto the land for a self-help. That's not something that most lawyers are going to recommend in most cases, but it can be a cheaper, quicker way of dealing with it. And again, given that these involve litigation, legal advice will be essential. I'm sorry, we are getting quite short on times. I'll keep the restrictive covenants as quick as I can. They are different to an easement, although they also go to controls, etc., over what you can do with land. Restrictive covenants are more of a contractual obligation that requires you not to do something on your land. So examples would include, for instance, keeping animals or birds, running a business, building on the land, changing the use, causing a nuisance, using it for Airbnb, parking rusty old caravans or boats, etc. So they're normally intended to sort of preserve the amenity of the surrounding properties. Um, Restricted covenants are capable of running with the land so that they will bind successive owners and occupiers. When you're dealing with acquiring land, the most common place to find them is in the charges section of the title register, but they are not guaranteed to be there. And so it's essential that you do full due diligence when you're acquiring a property and that you take great care when you're selling a property, because otherwise there might be a restriction and then there might be a claim. Some covenants may be anti-competitive, so competition advice would be needed on those. The three main types of restricted covenant, you can have them for personal benefit. They will just be a direct contract. You can have covenants to benefit or protect retained land. And you can have covenants, like a building scheme, where the covenants are imposed on the sale to everybody so that everybody can enforce them against one another. The first one is really quite quick and simple. If you have a covenant with somebody and they breach it, you can take action against them in contract. The most common one that we see is a right. It runs with the land. It will restrict the use of the land in the future, and that's again the most fertile source of disputes between parties, where somebody wants to do something with their property and somebody else doesn't like it. The third type is quite specific. You tend to find them on housing estates built into the 50s, 60s, 70s before people became aware of them and took them out. And it might mean that House 3 can sue House 7 because they've painted the front of the house sky blue pink with yellow dots on and nobody else likes the look of it. Looking at how the covenants run with the land, if you're both the original parties, then there'll just be a direct contract. But if either either plot of land has been sold, then it's necessary before you get too far down the line to check whether the covenant has actually passed with it. So the leading case on that determined that yes, restrictive covenants can pass when you sell the land is the Tulchan-Moxhay case from 1843. Now that case is why today we still have Leicester Square as a pleasure garden. I'm not going to comment on whether Leicester Square as it is today is actually a pleasure garden, but that is why it is open space rather than having been built on, because there was a covenant that said that had to be the case, and the court found that it was binding on the purchaser. So the criteria there, as with the easement, there are certain tick boxes that you must meet for the burden to pass. It must be genuinely negative in nature. It must be entered into for the benefit of identifiable retained land. The parties must have intended for it to be binding, which for covenants after 1st of January 1926 will be automatic, but for other covenants, you may need to look very carefully at the wording. It's important to read the covenant as it's intended, because even something that looks positive can actually be a restrictive covenant. So the Stevens and Ishmael case there on the screen, a covenant to use and occupy solely and exclusively as a flat, well, that's actually saying don't use it as anything else. It must be entered into, you must be able to benefit the you must be able to identify the land that's benefiting from the covenant, and that in itself can sometimes be a defence to a claim. So in the recent case, the Bath Rugby case there, it simply wasn't possible to establish what land would benefit from it. And a common example that we might see is where something's been sold out of a much larger estate, and it's no longer possible to, I'd say, it might say something like, for the benefit of the seller's retained land, full stop. And in the absence of a decent plan, which you often didn't have with an older conveyance, you've got no way of knowing what they might have owned at the time. So if no land was retained when the covenant was granted, it will just be a personal covenant and it won't run with the lands. If you had retained land but you've subsequently sold it, then you may be able to enforce against the original. If the person who gave the covenant still owns the land, you might be able to enforce against them if you could prove any loss, but you wouldn't be able to prove that against any subsequent buyer. Just noting, I do apologise that this has gone on a bit longer than I intended. It's currently 1 o'clock, so I will carry on. If anybody, well, there isn't that much further to go. If people want to stay, that would be brilliant. Obviously, if you do need to leave, I won't take it personally. So the looking at the next point, it is again, I keep banging this drum, but it's important to note that local authorities may have additional statutory powers. So in this case, you may be able to enforce a restrictive covenant against the successor in title, even if you no longer or do not own any benefiting land. That would arise in certain circumstances prescribed by statute. So there are planning ones, housing ones, conservation ones, etc. And it's also important to note the retained land must be capable of benefiting from the covenant at the time it is imposed. So if the covenant doesn't achieve anything, it's not going to be enforceable. And at the time that the person who is seeking to enforce the covenant is taking action to do so, the land must still be benefiting from that covenant. So you can't say, oh, well, 20 years ago, this was really useful. Um, Also, the parties must have intended the burden of the covenant to bind successors in title. Um, Again, as I mentioned before, it will most covenants these days do post-date this. There will be a statutory presumption that it's meant to bind successors in title. So if you want to try and rebut that, you've got to look very carefully at the document to see if there's any express wording to cap it simply at the original parties. Um, for if the covenant predates that, because some of them still do, then it will all turn on the wording itself. But that really, it doesn't help you with interpreting the covenant or the burden or the benefit. It simply gets you over one of the hurdles, which is that it will automatically bind successors unless you can prove otherwise. It's very important for restrictive covenants that they are properly registered. Um, for registered land, this can be done by way, again, this is something that the legal team or the conveyancers will do, but it can be protected on registered land by way of notice. If not, a genuine purchaser for value may well take the land free of the covenant. And so again, that can be really important. If you're taking the benefit of the covenant, you will want to make sure that it is on the title. If the covenant predates 13th of October 2003, it should still be noted on the title, just in a different way. Slightly more complex where the land is unregistered, because then obviously you can't put it on the title because the title is simply a bunch of paper in somebody's bank or safe. So in those cases, what we do when a restricted covenant is entered into, the covenant is registered as what we call a land charge. It's a Class D2 land charge, but those types of entries are made against the name of the owner rather than the address. And so if you're buying the land, you need to make sure that proper searches are done against the names of all previous owners. If these steps haven't been completed, as with easements, the covenant may not be enforceable in law. The benefit is slightly different to the burden if you're buying the land with the benefit. It's very rare to find the benefit of a restrictive covenant registered on your title. That is a little bit cynically, perhaps, but the land registry aren't necessarily too keen on being the arbiter of whether or not something is a benefit. So it can mean that you can have a benefit. So, for example, I had a case once where the client didn't realise that they had the right to veto building next door, and it only came to their attention further down the line because it wasn't on their title. So it can be tricky sometimes with the benefits. There is again an equivalent statutory provision that says the benefit of the covenant will be with the successors in title. So again, although it's preferable to have express wording that transferor and transferee include successors in title, it's not necessarily fatal if it doesn't. The benefit, though, will only run with the land if there is a sale, if the covenant touches and concerns the land. That means it's not merely personal. So a restrictive covenant, I don't know, not to put up Manchester United curtains for so long as Mr. X lives next door, won't survive once the parties have changed. But a covenant not to build a garage within so many feet so that it blocks rights to light obviously does touch and concern the land. The benefiting land must be easily identifiable. That is usually done by reference to the contract, but you can also use any admissible extrinsic evidence, for example, witness statements or something like that. The land must be capable of benefiting from the covenant, and it must be continuing to do so, and there must be nothing expressed to the contrary in the document itself. Whether the covenant applies to all the land or only part of it will depend on how it's worded and the circumstances. The starting point, though, is that it will be found to attach to every part of the land, again, unless there's anything specific in the documents. So the question of whether you might have said it's to benefit the garden only would be something that you would expect to see in there. But overall, the starting point will be the whole land gets the benefit unless you can prove that that wasn't the case. And you can see that can make things quite difficult in some circumstances. So if the council has a large piece of land and it's sold off in chunks, you might suddenly have, instead of one person who had the benefit, you might suddenly find 100 people have the benefit. And that can make identifying the beneficiaries very difficult. It is possible to word a covenant so that it will drop away as each little piece is sold. And then on the last sale, the sale of the last plot, the covenant will go all together. Obviously, that will very much depend, though, on whether you've got that specific wording or whether your conveyancers can include that wording. To touch and concern the land, the covenant must affect actually how the land can be occupied. So it must affect the value of the land as well, but by virtue of the covenant itself, not via secondary circumstances. So an easier way to word that is, does the covenant preserve the value or amenity of the land with the benefit of the covenant? A few years ago, more sort of 20, 30 years ago, you might see covenants that were put in place because they were really intended to try and claim a share of any future rise in value of the burdened land. That is not considered today to be a good way of protecting that sort of deal. What you would need there would be an overage deed rather than a restrictive covenant. But you do still find sometimes little strips of land at the edge of prime development lands that have a covenant against building, for example. That was the way it was done many years ago. Building scheme, they don't come up that frequently for this type of client, but that you may find them when you look if you look at all the conveyances where you've got something like a housing estate, you may see that there are covenants there that restrict what you can do with the plot to preserve the appearance and the benefits, etc., of the estate generally. The advantage here is that, as I said, it means that plot owners can take action directly against each other if they don't want them to change the character of the area. It can make things difficult, though, if you are looking to acquire a site. For example, say you want to acquire a house and convert it into a care home. If there are covenants on the overall estate to use it as, say, a single dwelling house for one family, that could then make it difficult. We do tend to see modern developers will usually exclude it. So they put wording in that says something like, it's, anybody, you can change whatever you like, and there will be no building scheme. But people weren't as aware of them 50 odd years ago. So they do still come up all the time where people are acquiring properties for development where there may be a building scheme in place. How can you remove a restrictive covenant? Well, you can agree an express release, but as with the easement, that may be expensive. You can get the consent of the beneficiary. So if, for example, the covenant says that you won't build unless the beneficiary has approved the plans, if you can get them to approve them, that's great. But if you can't find them, or if there's hundreds of them, then it's not necessarily going to be any use to you. Sometimes covenants will be limited. So in the V limited versus Bernard case there, if the original seller no longer exists, the covenant may have effectively died with them. The key to identifying the scope of the covenant will be looking at the definitions used and then the factual and commercial context in which the covenant was granted. So, and the case law can be really contradictory. So we've got one case there where the covenant meant the original beneficiary only, and we've got the second one where it did include successors in title. So again, case law, looking at previous case law is going to be illustrative, but it won't be a definitive answer for you with a question such as this. However, there is a helpful case there that says where the beneficiary does have power to exercise discretion. So, for example, to approve plans, there will then be an implied term that he must act rationally and in good faith. It may also be possible to argue that they have to act reasonably. The burden of proof will be on the party who wants to argue that consent has been refused or withheld unreasonably. So the key question is whether oh sorry, I keep doing that will be whether a reasonable party would have come to the same conclusion with the same facts in the same circumstances. It will be unreasonable for the person with the benefit of the covenant to try and force an advantage, for example, to get the land cheaply for himself. Good and bad reasons have been given for a refusal. The bad reasons will not outweigh the good. A good reason will still be enough. If a landowner has tenants, he may take their views into account as well. So in the 89 Holland Park case there, the long lease owners, the flat owners, were also able to put their views to the landlord. Now, that was in fact a resident-owned manco, so they were effectively the same people, but they might not always be. Then coming on to acquiescence. If you're trying to enforce a covenant and it's been breached for a long time and you've done nothing, you may then be prevented from enforcing it. But in order to do that, you would have to be aware of your rights. You'd have to be in a position to enforce them, but then fail to do so. So it's very similar to the test for an easement as to whether it's being done secretly, etc., or whether you should have known about it. But just because you let somebody get away with a small breach will not prevent enforcement following a more substantial breach. So if there's a covenant against keeping pets and you let them have a goldfish, that doesn't then mean that they could keep 10 Rottweilers. Quite often we look at if there is a restricted covenant affecting a target title. We look at whether you can insure against it. Now, insurers may or may not be keen on that. It completely depends on the circumstances and if there's an existing breach or if you're going to commit a new breach. The insurers obviously being a lot less keen on the latter. You may be able to buy the property with an existing policy in place, or you may need to put your own in place. Who pays for that will be a commercial negotiation, or you may be able to get an indemnity from the seller if subsequently someone objects to your use, or if you're selling, they may require indemnity from you for breaching it. So either way, it would be very important to check, are there any covenants and are they being breached? And the way to do that will be things like inspections, detailed pre-contract inquiries, and a surveyor's report. If you are selling, it's absolutely vital to give correct answers or very, very limited answers, such as rely on your own inspection, so that there's no claim for misrepresentation at a later date. I'll get through this bit very quickly because it is quite technical, but this is basically the statutory option of applying to the upper tribunal to amend or modify a covenant. It can be very useful if you fit one of the criteria, but it's going to take you, if it's challenged, it's going to take possibly 18 months or longer, and it's going to be expensive. So it's not a magic bullet. And the reason I'm going to give it a fairly light touch is that as the local authorities may well have other alternatives. But essentially, if you can prove one or more of these four grounds, then the tribunal may be persuaded to wipe out the covenant or to modify it, usually in return for payment of compensation. And so we've got obsolescence, impediment to a modern reasonable user of the land, the agreement of the beneficiary, or no harm to the beneficiary. That last one there is generally used for frivolous or vexatious objections. So you can rely on more than one ground, but you should choose the most appropriate. Ground A, everybody thinks ground A will be easy. It's actually really difficult. Most cases on ground A fail. That's where you're looking at changes in the character of the property or the neighbourhood. And the reason those claims often fail is because the test isn't really so much the character of the property and the neighbourhood. That's only one part of it. It's this third point, the material circumstances that render the restriction obsolete. And people tend to forget that they also need to prove that. And it's pretty high because if you can show that the covenant still has a practical benefit, then it's not obsolete. Ground AA is therefore the most successfully used, most commonly used ground. And that's where you'd have to be able to show that, first of all, the restriction impedes a reasonable public or private use. Secondly, that there is no practical benefit to the beneficiary that's really worth anything. or in particularly in the case of a local authority, maybe that it's contrary to public interest and that money is enough for the loss. So these are the key questions here. The court will ask these key 7 questions that they go through, and essentially what they're looking at is, does it impede it? Should they be able to do it? And should they have to pay to be able to do it? That's the gist of BAS. Examples of practical benefits. In Gilbert and Spore, there was a view or an outlook that was being preserved. Collins and Howell, peace and tranquility, and restriction of vehicular access in Green and Hayes Hall. But you won't be able to prove that the substantial benefit if it's extracting a ransom or an advantage, or it's not connected to the restrictive covenant. It's not usually enough to disrupt a restrictive covenant if it's short term, for example, during construction, but it will depend on what you're doing, whether you're also blocking up things like rights of way, etc., as to whether people take action. The public interest is generally a very narrow application. So most cases that go to the tribunal go on the grounds of breaching a private use. Local authorities may have additional statutory powers to object to having a covenant modified or discharged if they're a custodian of public interest. So, for example, in your capacity under the Housing Acts. But the objection will be based only on, so a statutory objection can only be done on those grounds rather than if you are, for example, just the normal owner of the property. Money will be adequate if it can compensate, which is obviously what most developers, etc., are looking to do. Money can be paid to make good any disadvantage or to make up the price because the property was cheaper at the time the covenant was imposed. There's no statutory formula to calculate the loss. I have put a couple of examples here where the courts have basically got their calculator, or the tribunal's got their calculator out. So 1.5% was the value. That wasn't the loss in value because of moving the restricted covenant. That was not found to be substantial, so they only got £10,000. 5%, i.e. £75,000, was not substantial. But where the loss was a 10% reduction in value, then money was not sufficient. So it is a little bit finger in the air. It will depend on the circumstances, but we can use these as an illustration for what the tribunal might do. Ground B is much less common as a litigation point because obviously if people agree, there isn't usually a dispute, but it can be tricky if there are lots of beneficiaries or if you're trying to argue that consent has been given and the beneficiary says, no, it wasn't. Where there's been a bit of shady action. So, for example, saying, oh, no, there were no objections to planning permission, when actually there have been objections, then obviously the agreement would not be binding for ground B. And finally, ground C, that's where you can say, if you change or remove the covenant, it won't hurt the beneficiary. That's a very useful ground if you can get that instead of AA, because then compensation isn't usually payable. But obviously it's narrower, so it tends to be used primarily where the argument is vexatious or they're just basically trying to put pressure on you. The people who object to an application to modify a discharge, usually the owner of the covenant, but can also include people like the original party, your mortgagee or a tenant, somebody who's got the right to grant or withhold consent under the covenant, or a statutory objector such as a council or the National Trust. It is for the objector to prove why they are entitled to object. The upper tribunal can basically make what order it wants following an application. It has a broad discretion, so it will take into account factors such as why the covenant was granted, is it valid. It's much less likely to budge a covenant if you're the original party than if you have bought the property subsequently. How old is the covenant? The older the covenant, perhaps the greater the chance of getting it modified or discharged, and whether there's been a blatant breach. There's going to be much less sympathy for somebody trying to modify it if, in the case on the board there, they've just gone on and built, knowing full well the covenant was there. Where there's a useful case for local authorities here, the Manchester City Council and Jackson case, you might get more leeway from the upper tribunal. If you're trying to promote something, then the upper tribunal might be reluctant to stop you from doing so. Another route would be to make an application for a declaration under the under Section 84.2 rather than the application to the tribunal under 84.1. That would just be seeking a declaration as to the scope of the covenant so that you can then enforce it. It's not done very often in practice because it's pre-litigation litigation. It's time consuming, it's expensive, and you can usually just get something like insurance instead. But it is a possibility. And finally, you'll be glad to hear, coming on to remedies for breach. Where a valid and enforceable restrictive covenant is breached, the primary remedy will be to apply to court for an injunction. But you can also seek or be ordered damages, either as well as or instead of. Where the breach is by the original covenant, or it's a bit more straightforward. If the property has changed hands since, then it will be equitable. And so that means the court has discretion. So the court will look at conduct such as delay or activity by the beneficiary. So if you try to claim that they built something 5 years ago, the court is much less likely to say, right, they have to tear it down. However, you don't want to rely on that by sitting back, having breached it and crossing your fingers because it's not guaranteed. And a claim may be defeated if the person who's committed the breach can challenge the validity of the covenant or argue that you've consented or acquiesced in the breach. The bases for awarding damages, they can be compensatory, negotiating, or profit share. The last one is obviously the steepest and it's not that often used, but the court will get their calculator out for the first two. So valuation evidence is important there. Each case turns on its own facts. It's difficult to predict what the court will do, but you might be more likely to get damages if you've sat on it effectively. And that's it. So we do have a small case study. All it is for you to read through and sort of highlight any red flags, which I won't do that now because we've overrun, but it can be, if anybody's interested, it can be circulated afterwards. And I just have a very quick look in the chat. So we've got we may come later to have some pointers and answers on the case study. Yeah. So what we'll do with that, as I said, we anybody who wants it can have a copy of it, and then in terms of answers, anybody who wants to complete it, highlight it, send it through with any questions, and I can go through them. So I think, unless anybody has anything else they want to ask, thank you very much for joining. You will get the opportunity to give feedback, which would be greatly appreciated.